Welcome to the Zoom room of Workers Unity, Nikhil and Aruna Roy from the Mazdoor Kisan Shakti Sankatan. We're going to talk about the new Rajasthan Gig Workers Act, which was just passed recently by the Rajasthan government, which was being hailed, I think, across the country as a landmark piece of legislation. So can you tell us a bit about the background and the struggles of the passage of this groundbreaking law in Rajasthan? What led to this coming about?
எல்லாருக்கும் வணக்கம். என் தமிழ் கொஞ்சம் broken. ஏன்னா நான் நார்த் இந்தியாலே இருந்திருக்கேன். அதனால தமிழ் கொஞ்சம் சரியா தெரியாது. நடுவுல தமிழ்ல பேசுறேன் நானு. ஆனா ஏதாவது தப்பு பண்ணானா மன்னிச்சிடுங்க, எனக்கு தெரியாது சரியான தமிழ். எனக்கு 77 வயசாயாச்சு. இதுல நான் 4 வருஷம் தான் தமிழ்நாட்டுல இருந்திருக்கேன். பாக்கி இயர்ஸ் எல்லாம் ஐ ஸ்பென்ட் இன் நார்த் இந்தியா. அதனால என் தமிழ் கொஞ்சம் அப்படிதான் இருக்கு. அதுக்காக மன்னிக்கணும். 2 விஷயம் இருக்கு. அந்த 2 விஷயம் ரொம்ப ஒர்க்கர்ஸ் ஆன்டி ஒர்க்கர்ஸ் 2 பெரிய ஸ்ட்ரீம்ஸ் வந்திருக்கு. ஒன்னு the first one is this whole liberalization which has changed the nature of the worker employer relationship completely. It's broken it into from employment to contract. So that has meant a whole new attitude to workers. The completely flimsy link between employer and employee, and the fact that the employee has absolutely no rights in many areas, where the employer is completely abrogated to himself or herself all the rights. That's one scenario which has been steadily increasing and baffling all of us who form unions or want to, because this is one-to-one. It doesn't allow for a group. We are a Sangathan. Mazdoor Kisan Shakti Sangathan. Sangathan means a union. Now, that union is not allowed to be formed. Furthermore, in the last couple of years, we've had national laws passed, which has actually fractured and truncated all the labor laws that were in favor of workers. So we've had legislative measures taken to weaken us. And so in this whole legalistic pattern also, we have lost out. So we are people who work with unorganized sector workers, and most of our workers go on contract to various areas. Most of the poor people in my area, for instance, in our area, go and work as contract labor in dhabas. Dhaba is a Hindi word for a street தெருவு சாப்பாடு shop. I mean, you open it and then அங்க போய் you sit truckers and ரோட்ல போறவாள்லாம் அங்க சாப்பிடுவாங்க. அங்கதான் போய் வேலை பண்றா. அவளுக்கு ஒன்றும் டென்யூர் கிடையாது, அவளுக்கு ஒன்றும் கிடையாது. அது வேற இன்னும் that is developed into a further kind of a disaster now, because at least there was a human relationship between the person who hired them and fired them. But now employers are becoming invisible. You don't see the employer. He disappears or she disappears into the void. So you're really working. I mean, I don't know about all this technology. The technology is good. Otherwise, we wouldn't be talking to each other today. But the negative impact of this technology is that we are really completely dehumanized, and the controls are slipping out of our hands into some unseen and unforeseen set of people who control our lives. So how do we fight against this was something which was baffling us in the MKSs for a long time. We were part of the major group that fought for Narega, for MGNREGA, for Noor Naal Vele, as they say in Tamil Nadu, the Noor Naal Vele, and that we fought for it, we got the government to pass laws, but at the same time, we were slipping away from any kinds of control on the other side. So when we were thinking about it, we also realized that there were ways which had to think out. We should not fight to get back the older system, because I don't know whether it's ever going to come back, but look at the flaws and the possibilities in the newer system. When we were looking for this, MKSS thought back on its experience to Pune. There is a very famous Indian called Baba Adhar, who set up something equally famous, more famous than him, which is called Hamal Panchayat. The Hamal Panchayat in Maharashtra is about 40-50 years old. And they have over 1 lakh members of hamals or head loaders, coolie, கூலி வேலை பண்றவங்க. அப்போ ஒரு கூலி வேலை வந்து இந்த சிமெண்ட் ஷாப்ல ஒரு கூலி வேலை, கிரெயின் ஷாப்ல இன்னொரு கூலி வேலை, சம்வேர் எல்ஸ். அவளெல்லாம் எப்படி யூனிஃபை பண்றதுன்னு ஒரு பெரிய ப்ராப்ளம் பாபா அடவுக்கு. தென் அவளுக்கு ஒரு கேரண்டி கிடையாது, கேரண்டி ஆஃப் எம்ப்ளாய்மெண்ட் கிடையாது, கேரண்டி ஆஃப் சோஷியல் செக்யூரிட்டி ஜீரோ. அவர் என்ன நினைச்சார், சோஷியல் செக்யூரிட்டி ஆங்கிள் எப்படி கொண்டு வரணும். So he devised this beautiful example of a tripartite body called the Mathadi board. And the Mathadi board was in conjunction with the Maharashtra government, and they actually enacted a law called the Mathadi law. And so the Mathadi board was enacted, and they set up this board where the coolie, that is the hamal, the employer and the government were in conversation with each other. And this whole board was operated by the government, where the employer had to deposit for every time he hired a coolie for in his name or her name, for health and for pension money with the board. So this seemed to have worked, and they have a fantastic, now they have a hamal bank, they have a hamal colony, and these hamals have now become very powerful lobby in Maharashtra politically also. So we have been always in awe of this wonderful example of what Baba Adav was able to do. And we thought, why not transfer this? And in this, Nikhil will go ahead and tell you the details. Why not transfer this to the contract labor, who are also, completely isolated, completely one-to-one with different employers at different levels. So how do we, but we have another problem now, which is that Baba Adav's employees, whoever they were, the contract employees, always had a face whom they saw. Whether it was Maya Ram and Sons or Ganeshi Ram and Sons, there was somebody who employed them. There was a man sitting in the shop. So for us, now there is a complete blank screen. You don't know who it is, except that you say, call it sometimes Ola, you call it sometimes Uber, you call it sometimes Amazon, but there is no face to it at all. So how do we tackle this? That was something which entered our heads. Also because we have people, we were working with two special groups. One was the people who work in these hotels. How do we deal with the hotel management people? And some other similar occupations. These workers who go from our area, workers, waiters or cooks or whatever it is. How do we get it from there? Now Nikhil will carry on from here.
Sure. Let's go to the next question. I think this is a background in terms of how our own thinking arrived at this question of what in the modern economy is called gig. It's not like that there weren't gigs before. The hamals were gigs in a sense, and that's why we picked up that idea. The only thing is that because of its great convenience to employers, it's called a gig as if it's some great freedom for the person who's being employed. And therefore, we reached back into trade union history and trade union struggles to find how people, because the unorganized sector in India is replete with similar examples of gigs, to find some kind of formulation that would allow workers to be able to get into collective bargaining, to get into a situation where they could have tripartite negotiations, and that background as well.
And the word gig itself was so confusing. So especially people of my generation, that word gig itself meant something very strange. We just couldn't understand how a word like gig could come into operation for fighting for workers and in what relationship. So that also had to be explained over and over again to a number of people as to what exactly is this gig.
But I think the important thing is that why we've gone into this whole background is that it's important to realize in workers' struggles of today that you are building on workers' struggles of the past. These ideas and breakthroughs are actually on the back of many other struggles of the past. And it's important to acknowledge that, because only then can you get into that continuum of seeing how workers do respond to difficult situations.
No, thank you for the history. I appreciate it a lot, and it does give some context for why you have your group has developed this approach towards having a social security legislation passed for the workers, which I'm sure will be of tremendous benefit. When I read that law, it seems like registration of workers, which is very important because they're no longer invisible and employers have to acknowledge them. Secondly, grievances. And here I have a question of whether it's only going to be individual grievances. And thirdly, what are the actual social security benefits? And you've mentioned so far pension and health. Are those the two major ones that you see coming out of it? And will it be only according to how much the workers have contributed, in the sense of how much is taken at each transaction that they engage in? So if you can just elaborate on whether my understanding of the law and the benefits is correct.
Yeah, it is correct. Registration. So first, I think if we take one step more, it's called the Gig and Platform Workers Social Security legislation. So gig, as we were explaining to you, a hamal is also a gig worker, as are maybe construction workers, or anywhere where you're asked to do this job and then the employer says, I have nothing further to do. But the platform is the second part of what Aruna was talking about, which is that you have this invisibility of not being able to actually talk to another human being. So a very important part of collective bargaining is completely removed because you are dealing with an app. All of us in the world know how when we have to deal with any kind of complaint on the phone, we talk to some bot or the other, and that bot, depending on whatever they are programmed to do, leaves us out in the cold most often. So here with workers, it's even worse because they are being dealt with by a dictatorial digital framework, and there's very little they can do. So one big second breakthrough that took place was the idea that since every worker on a platform is registered with the platform, if you register the platform, automatically all the workers get registered. So very, very big problem with social security legislation is the registration of workers themselves. In India, without the question of having digital systems, they are so dissipated all over the country in small groups, as we all know, in various places, or even individuals, that you don't have any way and means, and they don't have the wherewithal to get registered, even if there's a platform. Here, there was an opportunity of something that was being used to exploit them being turned on its head to actually catch hold of those who are doing whatever they were doing, because it's all there on record. So the law only needed a mechanism to say anyone operating on a platform in the state will be registered, and anyone registered on that platform will automatically be registered with the board. So that's itself a very, very big conceptual breakthrough in a sense. So registration, not just of the worker, it's also of the platform. So whether it's Ola or Uber or Zomato or Amazon or whoever else. The second, as you say, is social security. So a concentration on social security. Of course, there's much else that should come out of both collective bargaining and regulation. But they have been, all these platforms have been very successful around the world in fighting off regulation, because they say that it affects the market and that these kinds of laws cannot regulate their market mechanisms or they'll go out of business. We feel that that will come out of collective bargaining, but they have been able to successfully keep out of collective bargaining frameworks. So if we can get them in through something where even they don't disagree that every worker should have social security. And it's not just pensions and health, Aruna mentioned as an example, but the whole range is available. And so to your questions, the first answer is actually that immediately, let's say for transport workers, the day you register, you should be covered by accidental and death insurance, because that's something that would affect you even if you work for a day. But pensions is something that you would actually earn over a period of time. And no, it's not just you. Over a period of time, like EPF requires a contribution from the employer. So here, although the platforms have, or the aggregators have consistently said we are not employers, but they are employers even for 5 minutes or for 5 hours or for 3 hours. That's what this law establishes, that you have a relationship for that period and you're making a payment for that period. So just as you can say how much is an EPF share in someone who's working for a month, you can say how much is that EPF share for someone working for 3 hours. So actually, yes, through this, you should be able to get EPF and ESI, which are the two big things about an employer-employee relationship, through a new form of relationship. So there should be definitely an additional employer contribution to certain kinds of things over a period of time. And the third is that this law has been set up at 200 crores from the state government of Rajasthan. So 200 crores is not needed to set up a board. You need much less than that. But the 200 crores will go towards setting up the board and also putting some seed money into, yes, the state also. So the state does all kinds of social security contributions. So it can make for the beginnings, because this will need some help and push at the beginning. And Karnataka has announced, for instance, 3,000 crores. So what would happen? It's obviously wouldn't go to a board. So if Karnataka were to adopt the same model, the 3,000 crores could be used for contributing substantially until that social security board gets substantial resources of its own. And once it does that, then there are workers are there on that board. Gig platform workers are there, the state is there. So there are innumerable kinds of social security measures that could be thought of, which I won't go into, but it certainly doesn't restrict you to pensions and health. It could be education benefits. It could be for sick leave, because you obviously, if you do fall sick and you have an EMI to pay, what do? So you find gig workers working round the clock, working through illness, through sickness, because they have that pressure. It could give you some days of leave every year. It could do all kinds of things.
So thank you for that clarification and that explanation. Now, you also in the Act have this distinction between aggregators and principal employers.
Yes.
Can you explain that?
Yeah, so that was in the original bill. And many of our own friends and colleagues, because there were many consultations that took place between us meaning those of us who have been from either unions or from civil society groups or from citizens groups or from workers groups working on these issues and raising these issues, or even from think tanks. So we've had these consultations, and at the last one, actually, a big red flag was raised about this principal employer and aggregator being there. And therefore, the one big demand we made to the state was, please remove principal employer, because actually everyone is saying it will cause confusion. It was there with this idea, and I'll develop this a little bit later, talk about it a little bit later, is that some people are aggregators who are doing work of just all they are doing is connecting a consumer, let's say someone who wants to take a ride, to the person who's providing the ride. That's all. And for that, they're taking their commission. But there are others who are actually making you do a job. And you are not on an aggregating platform, but you're on a platform. So the thought of that, and to give you an example, is that let's say a construction worker goes to someone who's getting their house built. Now, the relationship is clearly between that principal employer, the person who's getting their house built or their building built, and the construction worker. There is no aggregator in between. And so our thought was that down the line, this is a very possible means of us getting a lot of other workers who are not able to get registered into this platform. But we were told by colleagues that this is only causing confusion. And as it happens, the aggregators also don't like the word employers anywhere at all. So there was, I think, from all sides, sort of pressure given on the government after that last consultation, that please remove this term, and it was removed. So it's not.
Please remove the
term principal employers from the law, so it's not there in the Act. It was there in the draft bill.
Okay. So just to clarify, so a company like Urban Company would be considered an aggregator, but not a principal employer. Is that right? Are you aware of that?
No. So everyone is considered an aggregator. Anyone who is using a platform is considered an aggregator. So it was in order to remove confusion. I personally feel, and this is something we'll have to deal with, is that when we deal with whoever we think is a clear principal employer, how do we term them and how do we get them going? But for purposes of this law, it removed any space for confusion or for passing the buck, as they say. because many people in unions felt by having both terms there, aggregators would say, oh, we are not principal employers, you go elsewhere. And principal employers would say, oh, we are not aggregators, you go elsewhere. So that's where from workers' side that objection was raised in the consultation, and it was removed.
Okay, okay. So just to, if I got it clear, then you're using both terms that all groups would be covered, whether they were more like principal employers. Or...
Now only aggregators is the only term there is aggregators, and it will cover anyone on a platform.
Okay, I have only read the bill in that case. I have not read the act. Maybe that is the problem.
Well, there's not much change other than that.
I see. Okay, that explains that. That's why I was not completely hearing you there. Now, you've already alluded to this. How have the aggregators now responded? Are they to the passage of this act? What changes have you seen since the passage of the act? I know the board has not been set up, but what are the workers reporting as to any changes that might have happened, or reactions, or aggregators leaving Rajasthan altogether? Is that happening?
No, I think that was so one very, very important thing that we felt. We congratulate the government of Rajasthan, actually, frankly, in this respect, is that they said there will have to be what they call stakeholder consultations. And of course, we feel there should be. Everyone should be consulted who is concerned. The only thing we keep pushing for is please have everyone in the same room at the same time. We said anything that we are asking for, we are suggesting, we are making objections to, we are giving feedback on is all in public domain. We'd like the same from them. And we'd like you to have your conversations with all of us together. And so that at least the official ones where you're doing these consultations. So that they agreed to, and that was vastly useful, because actually in that consultation that took place, 3 very interesting things were said. Some of those who had been working for instance, IFAT, a set of people, Federation of App-Based Transport Workers, their representative, when they said, oh, we have big issues with this central transaction monitoring system, that will be looking at it, because privacy of the workers will be removed. And here was a person who had worked trying to unionize workers for the last 10 years, who said one of the biggest issues is I can't get access to my own data. So what privacy are you talking about? You're taking my data, me as a human being, me as a driver, how many rides I've done, where I've done, what trainings I've done, and you don't show it to me. You don't show me what rates I'm getting and why. So they had no answer to that. Or they said, oh, this will mean duplication of burdens on us. Or it'll mean we are already giving insurance. So who stops you from giving insurance? But this will make sure that everyone follows a minimal level of giving, of contributing a fee over each transaction, which will be used to give insurance to everyone. One company may give, one company may not give. So having all of them there, we heard all their objections, and there were several objections. And those objections have been successful in many countries and places in staving off such legislation. But I think a big difference, that's where democratic consultation helps. The big difference was that we were there in that room, and it was clear when it was both minuted and when it was talked about, even with government later, they said, yes, the answers were there. So
there's one small interjection I want to make here, and that is that the nature of consultation itself is a huge political issue. How do they consult? How does a government consult? You know, and it's important that we ask for collective consultation, that we ask for equality in terms of that we ask for equality in terms of the worth of what we are saying. I mean, because, you know, generally what happens is that you have 2 people who are aggregators coming and meeting the government separately, and you have us meeting separately. And then the 2 persons, what they say outweighs what thousands of people say on this side. So we wanted that kind of consultation to be part of the negotiation. And this has had a history so far as we're concerned. It's gone back to the rights-based legislation days when we knew that unless we sat in on every discussion, and that we looked at every formulation of every section of the law, we'll be cheated. So that old experience carried forth into the new making of this new law helped us a lot. So that the negotiations are very important. The consultations are critically important, that it be equally weighted on all three sides, equally.